conversations are really something. But we were having a conversation about it, and I brought up a couple of things, and Kurt's like, why don't you come on and talk about it, because there's really the issues that are the fire service, the overtime issues facing the fire service, and I've been saying this for a while, Kurt's been saying this for a while, I think, is that one of the hottest issues, or the hot button issues, relates to the application of the executive exemption, or the white collar FLSA's white collar overtime exemptions on fire officers. And in particular, a lot of the attention is you find shift commanders, whether it's a battalion chief or a deputy chief, or et cetera. And when I say the FLSA white collar overtime exemptions, what we're talking about is there's a section of the FLSA. It's a complete overtime exemption. So in reality, it's also a minimum wage exemption, which is kind of crazy, but it is. In reality, what ends up happening is no matter how many hours that this fire officer works, if they're properly classified as an overtime exempt white collar employee, no overtime. So, provided you're paid a salary, and there's quite a few, hurdles you have to jump through from the employer's standpoint. But if it's properly applied, that individual could work 24 hours a day, 7 days a week, and is just going to get that weekly salary. So it is what I refer to when we teach the FLSA class. It's a powerful exemption in that. And I think that I relate being able to require someone to work 24/7 and not paying any overtime is a powerful exemption.
Well, when you say powerful, there's two sides, right? It's powerful for the city.
Yes.
It's actually not all that good for the firefighter.
It's horrendous for the firefighters, depending. I mean, obviously everything is a situation, and there are certainly instances, and I think the easiest instance to say is, say the fire chief is exempt. The fire chief comes to work Monday through Friday, God forbid there's a big fire. We know the chief's getting out of bed to come in, but the chief isn't bouncing back and forth on overdose calls, box alarms, things of that nature. So that, I think it's easy to kind of look at the bookends and say, yeah, the fire chief is exempt, right? I think that's a fair statement. It's not always the case, but that's a fair statement. But the further along you go on that continuum down the line, and there's a good argument to be made that some battalion chiefs and shift commanders can be exempt depending on the circumstances. And then eventually we get down to our line officers, which, I think the opposite bookend there is that your officer that's assigned to an engine or a truck company, they're going to be eligible for overtime. And again, everything is a situation. You have to look at
and we
facts.
Do have cases out there that say that company officers are exempt. So there's a mismatch
Absolutely.
of cases out there that kind of all over the board.
Yeah, absolutely. And the topic of our conversation that we had late this week was just this year so far. There have been 3 settlements on overtime lawsuits having to do with, 2 of them were battalion chiefs and one was fire investigators, fire marshals / fire investigators was their classification. So I figured I'll come on and just touch upon these 3, because I think it's relevant. I think it's we've in the classes that we've done, we've talked about this is kind of it's emerging, and that's some of the things that for us it's exciting to see these cases come out. And the settlements are kind of a letdown, because a settlement is valuable, but obviously what for us, for our standpoint, we like to see a decision, a
decision by the court stating something
exactly, because that kind of helps us with our parameters. So as much as the settlements, and anyone that's familiar with the settlement, and this is the way it goes. The settlement, basically, like the city will say, we were correct, we were doing nothing wrong, but here's some money to avoid the unknowns of litigation. And very often it's a smart move in this area, in my opinion. That's just my opinion, because it is such an emerging area, and you really don't know where a court is going to come down on this, where a judge is likely to decide on this, or in some cases a jury is likely to decide on this.
Was there a thread? Is there a thread between the 3 cases? Is there some similarities between the 3, or are they kind of? There
are. Well, there's 2 of them. There are similarities. Well, the one similarity is, according to the accusations or the claims made by the firefighters in the cases, they were being treated as exempt executives. So that's the one common thread that we can find. But then beyond that, 2 of the cases involved battalion chiefs, and there are some other similarities there. And then the one it was Selma, Alabama, was the city that, it were fire marshals / fire investigators. There was some additional facts there that are kind of relevant. The first thing is the city was, according to these marshals, and I'll just refer to them as marshals. They were marshals / investigators. The city was classifying them as overtime exempt. So the marshals got together, filed a lawsuit, started the process of saying we should be eligible. We think we should get overtime. In the meantime, and this case went on not years, but this case was dragging on for a little bit of time. In the meantime, the city, like many cities right now, they did a analysis of the salaries according to the plaintiffs. At least they did an analysis of salaries, and they gave large across the board pay raises to all members of the fire department. And that's something that I'm seeing a lot in some of the, we've got recruiting issues, we've got retention issues. Yeah. So it's not uncommon for, especially outside of collective bargaining jurisdictions, for the cities in the last few months or so to just come across and say, we're giving a blanket 5% across the board, or we're giving these folks 10%, or we're going to give a retention bonus, or whatever the case may be. So the city, according to these marshals, came out with an across the board pay increase because they recognized that the department was underpaid when compared to other, whatever justifications they came up for. Well, guess who they left out of that across the board?
Oh, the fire marshals?
The fire marshals. Oh, so Curt, just the reason why Curt's eyes lit up is, what's that? What is that now? They filed a lawsuit saying that they were not properly classified in the FLSA. The city turns around and says, well, we're going to give everybody pay raises, but we're not going to give the marshals there because we really don't know. And I can see this, like they don't know what's going to happen, right?
It's retaliation. It looks like retaliation.
Absolutely. So these marshals make the claim. It's making its way through the court process, and the city tries to get it thrown out and continues and back and forth. Well, then all of a sudden they come in and they say, okay, we got to add another claim now. We got this retaliation claim. Now, at the end of the day, they agreed to settle. And what is unusual here, and I know, Curt, you and I spoke about this a couple of weeks ago, it was quote unquote confidential, which is unusual when it comes to public, my experience, and you have obviously a lot more experience dealing with this. When it comes to public dollars, typically you have to show where where your money is being spent. They didn't here. The court agreed to seal it, and it was unopposed. The plaintiffs agreed, and the city agreed. So obviously the plaintiffs get their money. The assumption is plaintiffs got a decent little pile of money probably, and they're happy that if they got to agree to that, I'll agree to that. That's fine. But that's kind of how. So that's the different. That's kind of like the oddball out of the three cases that we're going to talk about there. But again, it was kind of unusual. So we don't know what we're looking at. I don't know the impact of that retaliation. And for
you don't know how much of the whatever the settlement is, how much was associated with the retaliation part, how much of it was the original claim.
Exactly.
And then we don't even know what the total amount is.
Exactly. So that was a little bit unusual there. The next two cases that we have are a little bit more of our, for lack of a better phrase, like bread and butter type of case. These are battalion chiefs. These are shift commanders. They both come out of California, and just so happens they both come out of California. The first one, let me look at my notes here, we'll talk about was Rancho Santa Fe, California. And that ended up was two battalion chiefs there filed the lawsuit. At the end of the day, and this is something that both of these cases share, which is, I think, is smart lawyering from, obviously plaintiff's attorneys might be a little frustrated because you're not going to have as much billing, but they both settled quickly. The city seemed to, at least from the outside looking in, which I think from the defense point of view is smart. I do, because why litigate these things out and drag them out where your legal bills end up being more than the actual damages? Maybe you're successful, maybe you're not, obviously depending on the situation. Here it was two battalion chiefs. The total settlement was for $99,000, and I'd have to look at the specifics to see how that broke down. I think it was around, I think it's each of the chiefs got between $34,000 and like $40,000, and another, $25,000 or so in attorney's fees. So looking at that from the 10,000 foot view, that's a pretty easy settlement as far as that they didn't litigate that out, they didn't drag it out. There, a lot of times we see it where these cases go on for months and months and years and years.
Yeah, years, and then you get appeals, and in the meantime, I mean, the total amount that they're owed, unless the city continues to not pay them the way they should be paid, very often we see them correct their payment, and then you just have sort of locked it on the damages. But what keeps going up and up and up are the attorney's fees. Absolutely. And you end up with attorney's fees of $500,000, $800,000, or the case that you use in class sometimes is that one that cost the city of Los Angeles over $1 million.
Over a couple $100,000 eventual settlement. Yeah.
It doesn't make sense,
Yeah.
you know,
No,
but
you're absolutely right.
but
And
people
also,
get so into the argument part of it that they can't kind of take a step back and say, okay, let's cut our losses here.
no, and you're correct. And another point that, and I really only recently began to think about this, speaking to attorneys that do this, and Brian Massat always likes to tell us when we're teaching the 24-hour class, he'll add in, you don't want to give all of this, you know, through the discovery process, you're providing piles and piles of documentation. You do not want to allow the plaintiff's attorneys more and more time to comb through that to find more and more violations. And that's a true point. You know, if they, you know, the plaintiffs bring forward A, B, and C, and you're so busy arguing over A, B, and C, at the end of the day, you're still, you know, in theory, you're still liable on A, B, and C, but now the attorney has found D, E, and F, and they're adding things to the pile. So there is a benefit to acknowledging it, certainly not giving away the farm, certainly not settling things that are not, you know, worthy of settlement, but and especially in these executive exemption cases, it is such a, you know, it's you're taking such a chance by litigating these things out, not just the legal fees, but the result, you know, and obviously that's
hey, before you get to the last case, I do want to just I just want to mention that this Wednesday you have your webinar on the EAP coming up. Yeah. So that's Wednesday, 1 o'clock Eastern. You can get the information either on my blog, Fire Law blog, or Bill has a blog too. And we should have mentioned that. You got your Firefighter Overtime blog. So it is firefighterovertime.org.
Yep.
And or you can just type in Firefighter Overtime and you'll find your way to Bill's blog.
Yes, it pops up the first couple. So now the other case that we have, and it was ironic because I titled it when I wrote the story, was another day, another FLSA settlement for a California battalion chief. And it was very similar facts as that Rancho Santa Fe. And this one was the city of Encinitas. I think I'm saying that correctly, California. And there it was a total of 4 battalion chiefs. It ended up very similar to Rancho Santa Fe in that it was a settlement of $145,000. You know, for the 4 chiefs.
Settle quick.
Yes, settle quick. There was a lot of commonalities. Obviously, the claims that were made in both those cases were that the chiefs really didn't have discretion to respond to alarms. The chiefs were assigned to a 24-hour or 48-hour shift. They had firefighting equipment in their buggy, in their the apparatus the chief drove around in, and they were required to, you know, we talk about these terms like engage in, you know, the firefighting. They were not a business leader. They were the shift leader, but they, in the process of running their shift, they actually engaged in firefighting, which, and those are all, you know, the key terms that we, you know, plaintiffs are going to try to establish. But the ironic, and this was something I didn't realize until this morning when I was kind of just going through the cases and reviewing my notes, when I went to the Encinitas lawsuit, when it was filed earlier in 2022, I wrote a story on it and provided a copy of the complaint. Within the body of that text, I talked about 2 recent lawsuits the month previous. One was out of Iowa and the other one was out of Virginia. Very similar. This is not just a California issue. This is not just an Alabama issue. This is a Virginia issue. I was looking through my notes this morning. We got a case pending, and, you know, another one in Virginia. We got one in Georgia, at least one in Georgia. We may have 2 in Georgia that are pending, you know, that are kind of making their way through the legal process. So it is a very hot button topic right now.
I don't know if you have the data on it, but I'm sure you have a sense for it. What's the success rate of, when I mean success, I mean, what is the percentage of cases that are filed that either result in a settlement or a verdict in favor of the or a ruling in favor of the chiefs being hourly versus chiefs being exempt?
I have, and I don't have scientific data to point out cases, but my settlement is the number one way these are being resolved. And typically what's happening with the settlements is typically, and it's not always, the agreement will be, here's a little bit of money for the last couple of years. Here's the money for your attorneys going forward. We'll provide you with overtime. And then that way there, it's not an issue. As far as jury verdicts, they are coming down, or legal decisions, whether it's a jury or the judge that's making the decision, they're coming down for chiefs in favor of chiefs. That's something that we are seeing as far as the majority
chiefs
of those
being hourly.
Being exempt. The chief being exempt. I'm sorry.
Okay.
So, coming down in favor of the, in
in favor of the city.
exactly in favor of the city.
Interesting.
And company officers obviously are coming down the opposite, in favor
Right.
of the company officers and not in favor of the city.
We should
That's
do a little
the
analysis.
majority.
Maybe you and I put our heads together, because I'm not
Yeah.
sure. I mean, I try to follow you, and I try to,
Sure.
whenever you find a case, I try to add it to my database. But I think
Yeah.
there's some gaps there, so we should probably we
Yeah.
should probably put that together. And then, I mean, not that it really means anything, because it's kind of like, I'll go back to my favorite metaphor there of a close play at second base.
Yeah.
But it would help someone who's in that position, because like if you've got to steal second base and you want to know what's the percentage, what's the risk here, or what's the likelihood I'm going to be safe at second base, this time's take a chance, this time's not to. And
Sure.
if we know that it's 50-50, or it's in this scenario it's 80%,
Yeah.
you have a better understanding of the likelihood of
No,
prevailing.
you're correct. But I also think with these settlements, I think what we're seeing a lot of folks doing too is, it's not, even though the decisions are coming down predominantly in favor of the city for these, high level chief officers,
Right.
but are assigned to a shift. I think that's a good differentiation there. Lawsuits still coming. Lawsuits are still going, because I think that they recognize that it's a true question, and why not? A settlement might end up getting the desired result for the employees, right? And at the same token, it's not slowing the flow of complaints and litigation. There's the Fourth Circuit came out with a decision a couple of years ago, Chesapeake, Virginia, is that Emmons versus Chesapeake, where the Fourth Circuit Court of Appeals said that these battalion chiefs in Chesapeake were exempt.
Mhm.
And that was a big, that was a big factor.
Right.
In last year, battalion chiefs in Alexandria filed a lawsuit. So they know that Emmons is out there, but obviously they think their facts are different, and different enough to the point where attorneys have jumped on to say, no, let's give this a shot.
Well, and again, going back to my analogy, it's just like if firefighter, here we go. If baseball player A slides in safe into second base, that doesn't mean if baseball player B is going to try to steal second, they're going to be safe. But if we say they got similar speed, and the catcher's got the same arm, the pitcher's got the same motion and everything, you can sort of predict. On the other hand, there's no guarantees. You could, even a fast runner could fall down, and even a good attorney could muff a case and not make the proper arguments, or blow a statute of limitations, or whatever it may be, and you lose the case on that. So you never really know. But I think it's helpful to know if in general they're prevailing, or in general they're not, and
Absolutely.
We're understanding that it may not affect that particular close play at second base.
Yes.
So
No, it's very, very true.
that's
Very
how I
true.
think anyway. That's how my brain works.
No, but it's good, because you put it in those terms, and then you can kind of you can relate easier. And that's what we use a lot of those metaphors.
All right. Well, super. Well, Bill, thanks for coming on. And Bill again has got his webinar. What's the name of it? It's Advanced FLSA.
Yeah, fire officers and overtime is the it's executive exemption, fire officers and overtime.
So we're going to go through all of the criteria that the courts would consider in terms of what makes someone exempt, and then apply those criteria to the fire service. Because, the executive exemption, when you're talking about someone who's a manager at Home Depot, or the manager of a McDonald's or whatever, there's one set of criteria. But when it comes to the fire service, how do those terms that make sense in private industry, how do we apply those? And then, of course, we have special regulations, the first responder regulations that come into play. So we've got to take a look at those. So again, awful lot of information. Bill gets through it in about 3 to 3.5, 4 hours. Usually.
And I'll be adding a couple more slides over the last month. At least there'll be at least an extra slide or two that weren't there, at around the first of the year. Because we got to acknowledge these things.
Yeah, the law is evolving, and just like in our understanding of the law is evolving. The more we read the cases, sometimes we speak to people who are involved in the litigation, and that helps us to have a better understanding of it.
And through my website, I know Curt gets questions. I get questions regularly. I average about one question a day. If I was to turn around and kind of look, I know you're probably five times.
A little bit more, but
I average about one a day. And last week I was away at a training at a fire academy for the whole week, like a live-in type of thing. So I kind of got behind on my questions. So this weekend I'm going through them and catching up. Last week I got 3 questions on this topic.
Wow.
From 3 different, and so it's definitely, I got, a number of questions, but literally 50% of the questions I got last week were on this topic. So it's out there. Folks are asking, they're asking good questions too. They're not just saying, hey, this is, they are, one of them, the person asked the question specifically said, I was reading Emmons versus Chesapeake and, so they're drawing, so it's a very, it's
people's knowledge, in this area is coming up, which is a great thing, which is a good thing. So.
Absolutely.
All right, man. Well, thank you very much. And folks, we'll see you again on the next edition of Fire Law Vlog.